Yes, Ms. Haripriya.
May I please, Your Lordships? On the last occasion, Your Lordships had indicated Your Lordship would like to see all the judgments on this issue. So
Yes.
we've actually filed some compilation of judgments where these issues are discussed. And we had filed it last evening, Your Lordships. Many of them are already in Mr. Hansare's compilation, some are new ones. So I can either take Your Lordship through some of the important ones or go straight away to my note.
Is there a note with respect to those? You have collated them and then formulated a proposal?
I've made a proposition note, like Your Lordships had indicated last time, on what the scheme should be and suggestion should be. Yes, Your Lordship.
That is how you have propositions.
Propositions by me, and there was propositions by Mr. Ragen, by Mr. Kuryakos, by Mr. Chetan Garg. I've sent all that.
Points,
Yeah.
the propositions or the findings that you suggest. Notes, yes.
Yes, Your Lordship. So my note has been submitted. If Your Lordship would kindly have that. At the outset, I mean, I'd also filed a detailed.
Through your submission.
It's called brief note on.
You got it, yes.
Haripriya Patna. Yeah, I'm sorry, Your Lordships. So this is a brief note. I had also earlier submitted a detailed 6-page written submission, but we just.
I think this is a crystallized.
We investigated based on what fell from my lords on the last occasion.
Yes.
Just at the outset, it is submitted that whether in principle a cutoff at all can be fixed for viva voce is a question which has been detagged from the present batch of matters. And this calls for interpretation of the Shetty Commission report and other judgments. And our request is that the said issue of whether a higher cutoff or low cutoff in interview can be fixed up may not be gone into at this stage, because whether a cutoff at all is permissible is still moot before another bench. So anything Your Lordship will say on that may impact it. That's just something we wanted to highlight at the beginning. And then the second point, Your Lordships, public recruitment must not only be carried out fairly, but also must be seen to be carried out fairly. When the selection criteria changed midway by the very authority that laid down the original criteria in the first instance, after the persons in charge have learnt of the individual performances of the candidate, an impression is created that the state is not acting fairly and the change is being made to unjustly favor certain individuals, even if the same results in making overall selection process more rigorous. This originally, the submission is that ideally no change should be permitted. Once there is rules and there is an advertisement pursuant to it, one should comply with it, and any change or departure from that can give rise to that suspicion. In fact,
now, when you say selection criteria,
yes, sir.
Selection criteria basically is a very amorphous phrase. Now, there may be certain types of selection criteria which constitute eligibility. So, a change in eligibility is one thing. Then there may be certain criteria which are not in the nature of eligibility, but say, for instance, shortlisting.
Yes.
Now, when your number of applications is unusually large. So, is it your case that the employer cannot change the criteria at all midway, or does it depend on the nature of the criteria that are changed?
So, based on what fell from Your Lordships on the last occasion, we have in fact made that distinction in our note. We have said about eligibility and at the final stage, when originally it's the drawing up of the merit list based on the existing criteria and the selection. Once the merit list is drawn up, thereafter at the time of appointing, the authority concerned may say, okay, I will only take the top 15, I will take only the top 10, I will not choose people who got less.
Quickly now lead to through your note, item 2 now.
Yes, point 2. Para 2. Every state action, there's a constitution bench in Channabasavaya which doesn't talk about change in rules, but in general about public employment where the standards are very high, and that there should be a sense of non-arbitrariness in the entire procedure. That has been referred to. Every state action is presumed to have been taken after due application of mind. Hence, it is presumed that the original selection criteria were framed after due application of mind. There is no reason why more rigorous selection criteria cannot be framed before the commencement of the selection process. Third, candidates have a right to know before the commencement of the selection process the standards, criteria on which they will be judged, so that they can modulate their levels of preparation. This is something what my learned friend Dr. Bharadwaj said, and for each of our points, we've footnoted cases where these propositions are found. Similarly, examiner should have a meaningful opportunity to modulate the marks awarded to the candidate in view of the eventual selection criteria. If I may pause, especially in the case of an interview, because an exam may still be more objective. In the case of an interview, as it happened in the Kerala case, If the interviewers do not know that there's going to be a minimum cutoff, they may give me a certain marks. But if they are aware that by giving me less than a certain cutoff, I'm going to be excluded from the final merit list at all, their considerations may be quite different while marking me. So it is not just the candidate, but it is also like in terms of interview and exam. I don't believe that a candidate will prepare extra for the exam. I believe you should anyway do your best and work hardest irrespective of what the cutoff marks are. But for example, interview, for any reason, I may choose to not prepare for the interview as hard as I possibly prepare for the exam because I think it's anyway an aggregate of both. But tomorrow I'm told, no, I'm going to fix a cutoff in the interview. Then obviously my criteria has changed. Interviewers also are similarly placed. They may have marked you differently, were they aware that based on a lower mark, you're going to be precluded from being on the merit list itself. So the fact is, everybody should know what is before them and what to anticipate. And that itself is a principle of non-arbitrariness. Because if the rules of the game keep changing through the process, nobody knows what to expect. Para 4. Overall, the selection process must not cause frustration to the candidates. In our country, a large number of unemployed youth apply for public posts, filling the forms, preparing exams, traveling to exam centers. In this background, as recently held by this Honorable Court, those who are successful and declared to be passed have a reasonable expectation that they will be appointed. Point number 2, and this is just our general principles why we say in general it should be a rule that once a selection process commences, criteria change should not be permitted. If your lordship is going to permit it, then it should be an exception to the rule and not the rule itself. Number 1. Number 2, no change in eligibility criteria unless advertisements and rule permitted. This is what fell from your lordships, that eligibility is different because I have a right to be considered. I don't have a right to be appointed. Now, therefore, there are judgments of this Honorable Court which very clearly says you have a right to be considered. So, if any eligibility criteria, meaning a cutoff in an exam or interview is tampered with, that will prevent my name from being in the final merit list, not the select list, but merit list. To that extent, eligibility criteria should not be changed at all. However, there are...
You formulated it.
I formulated, but there are two...
Oh, go ahead.
I'll read it. Articles 14 and 16 of the Constitution recognize a right to be considered for appointment on equal terms as other candidates. There can be no change in the rules of game so as to alter the eligibility process of any of the stage of the selection process, as a candidate has a vested right to be considered for appointment in line with the existing conditions laid down in the advertisement. I'll cite a judgment for this about why the advertisement plays a crucial role, not just the rules. This means that the eligibility criteria can neither be relaxed nor made rigorous, since a candidate has a right to be considered at an equal footing with and only with other candidates eligible as on the date of the advertisement. The reason I have made this proposition, Lordship, there were certain cases where after the advertisement, they have relaxed the cutoff in exam or interview. The question arose, more people are being considered. So your right is not being affected, you're anyway being considered. Instead of 50 people being considered, now 100 people are being considered. So how is it affecting your right to be considered? So this Honorable Court, 2 judges of this Honorable Court have said, no, it is your right to be considered with the people you are meant to be considered on the date of the advertisement. So if originally only 50 people were to be considered with you, but tomorrow, because of a relaxation, 100 people have been brought into the pool, it affects your vested right of being considered. So this change in eligibility cannot increase nor can it relax any requirement, because there also my vested right to be considered in accordance with what is laid down in the advertisement is being tampered with. And that is the second proposition we are presenting for your lordship. So eligibility conditions should never be tampered with, whether it is to make it higher or lower, because in the case of Tej Prakash, the specific issue was a higher cutoff. And that is what the court was concerned with at the time of reference. But tomorrow, equally a situation will arise. They will ask if it is reduced, then your right is not being affected. So can I reduce? Can I relax? So it is just so that if your lordship is laying down guidelines, this be taken into account.
Now, do you go to the third point that you have made? The
Yes,
third
Lord.
Roman point?
Yes, your lordships. And then as far as this para 7,
Cutoff. Power to fix it.
on the third point itself, power to fix a higher cutoff. Yes, your lordship.
So 3 covers changes other than those of eligibility.
Eligibility. At the fine, like Marwaha. So selection is complete and there is a merit list drawn on the basis of the selection process. Once that merit list is done, The authorities
No
decide, I will take only the top 10. So here I say once the various stages of.
There also you say that structure the discretion.
Yes.
Because they shouldn't really say that, give me the candidate, I'll decide what to,
Yes,
whom
Lord.
to appoint. One, you must follow merit. You can't take a person lower down in merit.
Yes,
That's what you
yes,
say.
Your Lordships.
Why don't you read it? You have formulated it well, actually.
Yeah, thank you. Right. Once the various stages of selection as advertised are completed and the merit list is drawn up, then comes the stage of selecting the candidates to be appointed from this merit list. As held by this Honorable Court time and again, no candidate has a vested right to be appointed. The selection committee appropriate authority can decide how many candidates from this list it chooses to appoint. However, this discretion is not absolute and is subject to the rigors of non-arbitrariness and fairness enshrined in Articles 14 and 16 of the Constitution. Hence, such a discretion has to be exercised keeping in mind the following safeguards. The list of candidates chosen must be in the order of merit, and no candidate can be picked up over and above her or him in the merit list. Any cutoff or criteria on the basis of which the final select list is prepared must be notified in writing along with the reasons. There are judgments from Harla and all your lordships where they say that all decisions taken should be published. It can't be in the secret chambers. So in fact, in the Kerala judgment case, we didn't know that they had fixed a cutoff for an interview till we moved RTI.
Normally, that's how it's happening.
So any cutoff or criteria on the basis of which final select list is prepared must be notified in writing along with the reasons. This is a basic requirement of transparency and the rule of law. Further, this would aid judicial review by preventing the recruiter from raising before the court as afterthoughts reasons that did not in fact guide the change.
So disclosure with reason.
Disclosure with reasons.
And third,
the cutoff or criteria should be decided before the merit list is prepared so that it does not appear to be tailor-made to suit certain candidates. Justice should not only be done, but it should seem to be done. For example, you just stop at a particular level. I mean, the question would always arise, why didn't you think of this a little earlier? So before, say, the aggregate is done, in the case of exam plus interview, before the aggregate marks itself, if the committee were to decide that we won't take anybody who have an aggregate less than 70, that would be fair. But after the merit list is prepared and it's in front of them, they choose, then it gives rise to a suspicion. Why did you stop here and not 5 marks below? D, last point, the rules of the game can be changed only in a way so as to make the selection process more rigorous. In other words, no relaxation, concessions, any other measures enlarging the zone pool of consideration should be permitted.
but this will really not arise because really speaking, once the process has been undergone, then the employer will only say, well, I'll only take the first 10. I will apply, say, a cutoff of 75% mark or 60% marks. They're not going to, if there was a cutoff which was notified earlier of say 60%,
Yes, ma'am.
and the employer then says, no, I'm applying a cutoff of 75%, that ex facie that's illegal.
Yes, Your Lordships. It
You
happens.
can't widen the field of.
Yes, you can't widen the field. And just to point out, Your Lordship, Manjushri's 3 judges, there is a Manjeet Singh, which is exactly contrary to Manjushri, which is also 3 judges. Manjeet Singh versus ESIC.
Will you just give us a citation?
Yes, Your Lordships. It is 1990, Volume 2, SEC, 367. It's there in the compilation we have submitted, even Mr. Hansaria's compilation, page 97 of Volume 1 of his compilation. This is 3 judges contrary to Manjushri. And as far as the advertisements are concerned, Your Lordships, even a recent judgment of this court of 2023 has very clearly made a statement that the advertisement should carry it and you have vested right as on the date of the advertisement. And that just having one is whether the rules permit a change. Second is whether you have conveyed that in your advertisement.
Can we just see Manjeet Singh for a second?
Yes, Your Lordships.
It's in this compilation which you have given us now?
Yes, in my compilation it's at page 62.
Volume 1 and Volume
Yes,
2, right?
Volume 1. Volume 1, page 62 in my compilation. And Mr. Hansaria's compilation, page 97, thanks. Para 2 and para 6.
Let's just see that.
Which volume you said?
Volume 1.
Volume 1.
Page 62.
Yes.
This is again a case where there was no interview marks cutoff prescribed.
Let us see what they say.
Yes, Your Lordship. Para 2, as already indicated, the direct recruitment was on the basis of examination and interview. The advertisement did not prescribe any pass marks in the interview, though for the written examination, 40% was prescribed. Selection was, however, made on the basis of 40% in the interview test, and those who did not secure 40% in the interview were not selected. Challenge was made by the unsuccessful candidates, questioning their rejection by contending that in the absence of any prescription of marks for the interview, there was no justification to apply the 40%, similar to Manjushri. Then straight away, if Your Lordship will go to para 6, at page 64 of the compilation, bottom. So far as this remaining question that was debated before the tribunal is concerned, we are of the view that the scheme intended for recruitment should be on the basis of an examination comprising of written test and interview. We agree with the submission of Sri Madhav Reddy that interview has its own place in the matter of selection, appropriate to require every candidate, selection process and the choice of the candidate. Once this is recognized, it would be appropriate to require every candidate to pass the interview test, and for that purpose, there should be a basic limit provided. In the absence of any prescription of qualifying marks for the interview test, the same prescription of 40% as applicable for written examination seems reasonable. That has been also the view expressed in so and so and so and so. We approve of the view. Accordingly, we modify the direction of the administrative tribunal and hold that in the oral examination, the pass mark shall be 40% and 40% marks shall be.
So here again, they had put this cutoff of 40% after the process had begun. And this judgment in Rajesh Sood was Justice Punchi's judgment in Punjab and Haryana in the Supreme Court.
I'm told it's not reported and we've not been able to find it.
Oh, I see.
That's what.
जरा ये देख लो, ये राजेश सूद वर्सेस डायरेक्टर जनरल एम्प्लॉय स्टेट इंश्योरेंस कॉर्पोरेशन decided on 7 August 1985. ये पेज 65 को मिलेगा वॉल्यूम 1 में. ये चेक कर लो, ये it is the Supreme Court. I think it must have been more. It must have been.
नहीं आया होगा.